Okay, hello and welcome to our virtual training series on local government law. For those of you who are unable to attend the first two sessions, the trainings are intended to provide a concise overview of the legal aspects of being a local elected or appointed government official. The sessions are based on select chapters from the book authored by Jerry Fisher, our presenter today. The book is titled Local Government Law, a practical guidebook for public officials on city councils, community boards, and planning commissions. Jerry's a well-known and respected land use attorney with decades of experience working throughout Southeast Michigan. Before we get started, just a few reminders. The session's being recorded and we'll have it posted on our website after today. And also I wanted to ask you to direct any questions using the chat function. Send them to Jim Schaefer. Jim's going to moderate the questions and we'll hold a question and answer period after Jerry's presentation. So let's get started. Please welcome Jerry Fisher. Thanks.
Hello, everybody. Welcome, and 1,000 hellos to each and every person out there. I very much appreciate you attending this session, and hopefully I can impart some good information. I know local governments are really a critical component of the American system of government. Local officials can do astonishingly good things for their communities, and the goal here in this program is to facilitate that ability for local officials. Today we're going to talk about a lawmaking power of voters. So this is going to be the direct democracy arrangement, initiative, and referendum. Everybody's familiar with those words. Hopefully we can provide some additional information for you. And then the second half of the program will be on the Fair Housing Act, another familiar phrase for people. And we're going to look at it in particular on how it is applied to local government. Okay, and as Brian mentioned, this is a course that is based on a book that I wrote, published by Routledge, Local Government Law, Practical Guide for Public Officials. And Jim told me not to mention that it's available on Amazon. So in any event, let's get started. Lawmaking power of voters, initiative, and referendum. So first question is, what form of government was established in 1789 when the United States Constitution became effective? And that was a question that was put to Dr. Franklin shortly after the Constitution was put together by the convention. And his answer was, "Madam, it's a republic, if you can keep it." And so they created this republic, this representative form of government, rather than a full democracy, which was rejected by the convention. And this form, the republic form, lasted in that capacity for roughly 100 years before any significant change was made. And so we fast forward to the late 1800s, early 1900s. And at that point, a group of people referred to as populists advanced a concern that there was just too much influence on the part of interest groups and lobbyists in the straight republic. And so their proposal was to provide some greater direct democracy and put that in the hands of the people. So this new layer of direct democracy led to the powers of initiative and referendum. So let's take a look at initiative and referendum, and it really is something that applies in the states. And keep in mind that we're talking about legislation. Initiative and referendum applies to legislation, lawmaking. And it is not a matter of initiative and referendum that might relate to administrative decisions. And this is a key distinction when the direct democracy format is being considered for a particular issue. Just keep in mind that it's really applicable only to lawmaking and not to carrying out a law. So let's look at what these two animals are. First, initiative, power of electors to directly place proposed legislation on a ballot for adoption without involvement of the legislative branch. So it's really the public can write it, put it on get it put on the ballot, and then pass it without the legislature taking action. Referendum is at the other end of the process. So, and this is the power of electors to directly place on the ballot a proposal to reject legislation that was actually passed by the legislature. So it's like a veto of what the legislature has done. Now I just have a separate page here for you on initiative and referendum in Michigan. And initiative, which takes an 8% petition, 8% of those voting, all the people voting for governor in the prior election, and referendum takes a 5% petition for purposes of state laws. So this is to create or reject a state law, and this arises under Article 2, Section 9 of the Michigan Constitution. And then there's initiative actually for state constitutional change, and this happens regularly. And that takes a 10% petition, which is not an easy thing to do, of course, and it shouldn't be. And that's in Article 12, Section 2 of the Michigan Constitution. In terms of state and local government, the authorization of permitting initiative and referendum for charters and for local ordinances, if approved in the charter, is found in the Home Rule Cities Act, Michigan Compile Law 117.4I, subsection G. And there is a referendum and initiative applicable to charter counties, and that's at MCL 514N. I previously had it 415. I think it's 514 subparagraph N. And it's a mandatory charter provision for charter counties. And then there is an argument to be made that villages can have referendum and initiative for their charters and ordinances, but it's not as directly stated, and it's something that would need to be argued. So again, the direct democracy legislation is not intended to replace the republic form of government. The new wave of political thought was looking to supplement the prevailing system, and essentially created a new layer closer to the people. So it gives electors at the state and local level an opportunity to sidestep or for referendum to check elected officials by using the direct popular vote. And the truth is that this methodology is used in many states, and it's something that has to be empowered by the state constitution or state law, or both. And absent an authorization, the power is not going to be there, and I assume in most states. And the power is also given to local government electors based upon enabling authority in the local charters in cities, and that's for sure, and maybe in villages. Now there is a state authorization for initiative in local governments for marijuana ordinances. So that's in that the law passed authorizing marijuana ordinances, recreational marijuana. In addition, there is a referendum for legislative actions for zoning, and something that is kind of a quiet thing. It's not used very often, at least so far, And that is when a local government is going to issue bonds, there has to be a publication giving notice, and then there's a referendum right on the issuance of bonds. But again, absent these outlier provisions for townships and general law counties, there is no initiative for ordinances in townships and general law counties or referendum. Okay, so this direct democracy concept has had mixed reactions by people in the state of Michigan and elsewhere. And some take the position, maybe on a reasonable basis, that these forms of lawmaking give a disproportionate amount of power and influence to those with more money, which is interesting because that was the rationale used to create this layer of government. And as you probably imagine, how do you advocate? How do you get, especially on a statewide basis or even on a local government basis, how do you advocate for these things? And it takes a lot of money. And it actually takes a lot of money just to get petitions signed, and then a lot of money to get people to vote one way or the other. So the response of supporters of these powers is that at least with this form of lawmaking, it's a little more transparent in terms of who's spending the money and so forth. And I really raised the question for you to answer, and I'm not so sure that that's always correct. Okay, again, these powers of initiative and referendum, absent authorization in Constitution or law, no implied or inherent right. So if it's not authorized at the state level, you can't do it. And to reiterate, the subject matter of this form is solely for legislation, not undoing an administrative action that has been taken. Raise a question. As you know, rezoning property takes a legislative act to amend the zoning ordinance. What about where rezoning has been denied and then a lawsuit ensues, and then the local government and the property owner enter into a consent judgment? Is that subject to referendum? The Michigan Supreme Court, as far as I know, has never addressed that question, but in 2003, the Michigan Court of Appeals did, and said that a consent judgment is not subject to referendum. The other limitation is that the legislation that is being subjected to initiative referendum must be a subject matter that is within the authority of the local government to address. So let's just focus for a moment in each of these individually. If initiative is authorized, it can be used to create or amend a local ordinance, or in a city for sure, a charter provision. And it's used for those purposes regularly. And then the question arises there, can initiative be challenged before the election occurs? And that has been attempted several times. I can recall it happening in Detroit with regard to an authorization on making marijuana a misdemeanor or a ticket. And the answer to the court has given on this subject is that a challenge can be made in advance if a defect, like a constitutional defect, appears on the face of the proposed initiative. So in other words, it's invalid even without applying it. So if it proposes initiative for administrative action, that would be always invalid. So courts might be willing to take that on without a vote. On the other hand, if the law must be applied to know whether it's going to be unlawful or unconstitutional in any particular case, the courts are probably going to let it go to an election first and then answer that question. So an example here would be the claim that a law would have a discriminatory effect when or if it's applied, or it might have a discriminatory effect, or could have a discriminatory effect. But one practical thought is the court lets it go to an election. Since courts are elected, it's a very low likelihood that the court is going to overturn the initiative after a public vote, especially if it's a significant public vote. So one clear weakness of creating a detailed ordinance by initiative is that there's no debate, there's no deliberation or compromise, and it's very challenging for electors to fully grasp the meaning of a whole statute that they're going to, or ordinance that they're going to have to become familiar with, or statute. And that was the case with regard to medical marijuana. A whole statute, nobody had any idea what they were really voting on, and I think there were probably 3 or 4 Michigan Supreme Court cases that were needed to clear everything up. Not that they've cleared everything up. So the vote is really an all or nothing proposition. No discussion, no modification of details that are obviously problematic, and so forth. So that's really a clear weakness of using the initiative approach. What about referendum? So this applies after the legislative body has passed a law, and it is being put on the ballot for the public to say yes or no on whether it becomes a law. So when a petition for referendum is filed, the the electors can then vote in judgment on the law that has been passed. If they vote that they want to do away with the law, then it's done, and it's as if it never been passed. And generally speaking, once a petition is filed, the law is generally suspended pending the electorate's vote. So in the meantime, the legislature might be inclined to pass a law that is substantially the same while the vote is pending, so that they don't lose any time. But the courts have indicated that they can't pass the same or substantially the same law. Now, in Michigan, I believe at the state level anyway, the legislature is able to vote to repeal. In other words, it's put up for a vote to the people to whether it ought to be repealed, and the legislature does have the right to repeal the law before the popular vote. Again, important limitations on the use of these two powers. It's got to be legislative, not administrative. In addition, you cannot use initiative on a law that would threaten the public health or safety, or existing public institutions. And you can't use the initiative to reduce or undermine a local government budget. You can't impair local budgeting by this process. Okay, let's turn to part 2 of this subject then, or this session today, the Fair Housing Act, and the Fair Housing Act as applied to local governments. So this is an act initially passed in 1968. I think it was amended first in 1974, then again in 1988. And this is the most pervasive congressional effort ever been made to deal with the fair housing issue. And of course, fair housing, public health, safety, and welfare would normally be a state function. Congress has passed this statute on the theory that there is a significant amount of discrimination in housing throughout the country. And under the 14th Amendment, subsection 5, the Congress is given the authority to legislate where there is a widespread discrimination in the United States. And so this would be an example of that exercise of power. All right. Now, let's look at the history of housing after the Civil War. Obviously, the fair housing was not a significant issue before the Civil War. It was all bad in terms of discrimination. But after the Civil War, we have the 14th Amendment enacted, and the first major case on the subject had to do with criminal law, where an African-American person was convicted of murder, but there were no white jurors permitted. And the court said, well, that's an important central civil right, and therefore that's really what the 14th Amendment was directed to. And so this conviction is overturned. So it didn't permit that. However, a few years later, in 1896, the United States Supreme Court is presented with Plessy versus Ferguson. And this involved a challenge to the constitutionality of Louisiana's Separate Car Act, passed in 1890. And the case interpreted the 14th Amendment to permit equal but separate, better known as separate but equal, train car accommodations for white and non-white passengers. So the separate but equal doctrine was established in 1896, and that doctrine lasted for more than 50 years in this country. And it lasted until the Supreme Court decided its 1954 decision in Brown versus Board of Education, which was a landmark school segregation case, as most people know. And I just point out as an aside that the case was actually argued initially in 1953, and the court deadlocked on what to do with it, and so they really had no clear direction to go. So the court ordered new briefs to be filed, or argued again in 1954. In the meantime, the Chief Justice died, and a new Chief Justice came in, the former governor of California, and the result was a unanimous decision in 1954, holding that separate educational facilities are inherently unequal and deprives equal protection. So that's and that little story comes out of some autobiographical records by Justice Douglas many years later. So notice that 1954 is right after World War II. And so this doctrine of separate but equal was in place during World War I as well as World War II. And that raises this interesting thing that, at least interesting to some, during these two world wars, two events occurred called the Great Migrations. And both of these events occurred in the era of separate but equal. The Great Migration is the name given to these two large-scale movements, primarily out of the South, involving 5 to 6 million individuals, largely Southern Blacks. And the path of these migrations led to northern cities, Western cities during the two world wars. And the migration was seeking the promise of manufacturing jobs and a new life. The fascinating thing about that is that here you have Detroit, which was a major a seat of manufacturing, and there has been there was a 2012 post done by the archivist for the American Federation of State, County, and Municipal Employees, AFSCME, that is contained in the Walter Reuther Library at Wayne State University. And this post indicates, and I won't read the whole thing, of course, but in 1943, a fight broke out between African-American and white Detroiters spending their Sunday on Belle Isle, the city's large park in the middle of the Detroit River. Many factors contributed to the tension that was finally released during this race riot. And Detroit's auto factories were converted to manufacturing material for the war effort. Detroit experienced a large population influx from around the country to fill jobs created by the war's demand. So this would have been part of the Great Migration. And so how great was the migration? Between 1940 and 1943, Detroit's population increased by about 500,000, which is roughly a third of the total population of the city at the time. And so what happened then is that a lot of the tension occurred because there was competition for jobs. And notice then that when the Great Migrations occurred, both of them were during this era of separate but equal segregation. So the suggestion here is that although there were other significant causes, many significant causes, I mean, basic racism would obviously be a cause, but the conjunction of the separate but equal doctrine and these great migrations would have meaningfully, this is my supposition, would have meaningfully contributed to the housing issues that motivated the enactment of the Fair Housing Act. And that's where I'm going with this, is that why was the Fair Housing Act enacted? And I think these two events would have led to some serious housing issues that ultimately led to the Fair Housing Act. Before we get further to the Fair Housing Act, let's look at some other reasons why the act is significant. Let's again jump forward to post-World War II movement to the suburbs. So following World War II, another movement occurred, this time involving a national movement, I should say again involving a national movement from older urban cities to newly developing and expanding suburbs. And again, this was facilitated by improved vehicles, new interstates being developed, like from downtown Detroit to Southfield, other improved roads, and then something referred to as redlining. And redlining, which occurred some time ago, so it's not as familiar to many people, but it was financing in older urban real estate was made more scarce during this time. The money was being attracted to the suburbs because the rental prices were higher and all that. And this problem, the lack of financing, was actually aggregated to a greater degree by something known as redlining. And this involved official government identification of areas of cities that would receive inferior mortgage lending and related financial treatment, often corresponding to housing classified on the basis of race. So these kinds of things then were another factor that would have contributed to the motivation for the adoption of the Federal Fair Housing Act in the 1960s. So what was the Fair Housing Act doing? What was it targeting? Primarily targets private real estate sellers, landlords, and lenders. In other words, you can't discriminate in the sale and rental or finance of housing. And so, in a nutshell, FHA forbids discrimination in the sale, rental, and finance of housing. Now, so where do local governments come into this picture? Courts have actually interpreted the FHA as being applicable to local governments based upon the following language. Fair Housing Act makes it unlawful to refuse to sell or rent or to otherwise make available or deny a dwelling to any person because of race, color, religion, sex, familial status, handicap, or national origin. So what the court has looked for, I mean, it could be refusal to sell or rent if the local government is dealing with housing directly, but it's really taking action that otherwise makes housing unavailable to a person in one of the named classifications in the Act. So how does that happen? When does this arise? Local government liability under the Fair Housing Act for failing to make housing available can arise in three primary contexts. I mean, it can arise elsewhere. I'm not suggesting otherwise, but in these three contexts in particular, planning and zoning, denying municipal services such as utilities, and failing to accommodate people with disabilities. So all three of these things are within the steady diet of local governments. So let's break them out. Planning and zoning. There are two angles to this. Even before the Fair Housing Act, there were claims made throughout the country of exclusionary zoning. What does that mean? That means that where zoning established regulations that pushed the price of housing units, maybe land even, housing units beyond the affordable range, and then likewise a refusal to rezone in cases involving protected classes. Another area would be exercising land use authority in a manner that makes housing unavailable for one or more of these classes, such as racial or national minorities. And the typical example here would be denying low-income housing. So, and these are things, again, all of the above, you might say, can happen at any time in local government. Denying low-income housing, you hear people attend local meetings all the time and say, why don't we go for exclusively high-end housing in the local government? And if the government buys into that and removes the authorization for low-income housing, this is where the Federal Fair Housing Act might take center stage. Municipal services. For proposed new developments that require utilities such as public water and sewer to make them feasible, this opens the door for a potential for adversely impacting one of the classifications enumerated in the Act. So a local government decision to deny an extension of a required utility service for a low-income project might make housing unavailable. And what the courts are going to look for here is, are the local governments extending these services to other developments that are not for low-income housing purposes? And if you've got a yes on that score, but a denial to low-income housing, you then have a potential for a fair housing case. Accommodating people with disabilities, and this has been going on since the 70s, shortly after the Fair Housing Act was adopted, by including handicap as a basis for discrimination in the 1988 amendment to the Act. Congress sought to allow people with disabilities to participate in mainstream living to the extent reasonably feasible. So this is where a reasonable accommodation must be made under some circumstances to allow people to have access to housing that might otherwise be unavailable. And so when the local government enters into this scheme, the local government can have a liability. And the way handicap has been defined in the statute in the courts, it can be very broad, and that is something to keep a close look on. So the example would be denying a facility intended to provide treatment for persons with disabilities. And these cases are getting stronger and stronger. I mean, from the 70s and 80s and 90s, these cases primarily involved housing for the elderly, maybe housing for handicapped, 6 or fewer people primarily, and then there were some cases with a few more. But this is branching out for places like housing people maybe permanently or semi-permanently, or even for a short period of time, halfway houses for people that are locked into addiction, and people that have had a problem with alcoholism and are looking for sobriety. There are these sober living facilities, and they can fall into these categories very easily, and have. So local government law relating to the liability under the Fair Housing Act is still in the developing stages. We can really expect to hear new developments in the months and years ahead. And I can tell you now, obviously, I didn't want to go into legal technicalities on this, but the court, I think the case was in 2015 from Texas, where the court has allowed an easier track for proving discrimination. The traditional track for proving discrimination in this kind of situation is where the plaintiff has to prove that the government intentionally discriminated to create these problems. And the court approved, the US Supreme Court approved in this Texas case, the potential of using discriminatory effect, which opens a lot more daylight for plaintiffs. Now, in coming to that decision, the court didn't narrow things to some degree, but be alert for new cases that come out of this, and to bear in mind that when we're talking about the Federal Fair Housing Act, there are money damages and attorney's fees potential in the case. So they can be big cases. They can, these are the kind of cases that attract plaintiffs' lawyers from Washington, D.C. and elsewhere. I mean, you might have a one facility case rejecting a facility for sober living, and then you've got these plaintiffs' lawyers taking these kind of contingency and riding the horse pretty hard. So this is a new and complex area, and I very much recommend that attempts be made to make an effort to meet the challenges of these areas up front and provide ordinances that will provide a process for considering whether or not a particular plaintiff's case or petitioner's case is serious enough to grant a reasonable accommodation and that kind of thing. So that is very important. And this presentation is really to alert everybody to the potential for future litigation in this area. So open for questions if any have come in. I look forward to hearing them and deflecting them to Jim and Ryan.
Okay, Jerry. First question. It's a question on zoning. Is a city obligated to make space available specifically for a certain group? For instance, we currently have no senior housing, but is the city government obligated to give first choice or preferential treatment to those builders?
I would not say a preferential treatment necessarily, but if you've got a group that comes in saying that we would like to find housing in your city, we don't find any place for it, and here is a developer that is willing to put it in, and has the financing for it. Then you've got to really look at whether or not a reasonable accommodation should be given for that particular project. And reasonable accommodation can be complicated. It's the burden of the applicant to demonstrate the entitlement to reasonable accommodation, but and it is required in many instances. So I wouldn't say just across the board that there's a need to give a first look at this, but if there's a need for this type of housing that's unavailable, then by rejecting it, you may be falling into the language of the act of making housing unavailable for these people.
Okay, another fair housing question. What about a rural township where municipal services are generally not available? How is that viewed when the township has none of those services to provide?
Okay, great question. If the other question was a great question too. Don't get me wrong. Well, if the local government does not have these services, then they will really not be in a position to discriminate on allowing them or not allowing them. So I don't think that the government would be obligated to install public water or sewer, for example, in order to accommodate facilities. Now, let me look at that from another angle. I mean, let's say that the rural township is next to a city, a good-sized city that does have public services, and that city has come forward and said, yes, we're willing to enter into an intergovernmental agreement to provide these services. That might change the picture to some degree. If the proposed development is going to provide housing for, say, disabled or low moderate income or whatever. I mean, but again, it's just a matter of making a reasonable accommodation, whether a reasonable accommodation is required.
Okay. And before I move on to the next question, folks, if you have any questions, put them in the chat box to me and I'll get them to Jerry. How common in Michigan are referendums and initiatives? And do you have any sense of the percentage, like approvals, denials?
I don't have really good statistics. They're very common. They're very common, and they're I'd say more common at the state level. So every 2 to 4 years, you're going to find these propositions to amend the state constitution or amend the state statute. There aren't as many referendums that are referenda petitions that are filed at the state level or the local level for that matter. But I'd say, it is an instrument. These are instruments that have increasing use. I would say, I remember it was like 2012. I think there were 8 initiatives on the Michigan ballot, and all of them made it to the ballot, or no, all of them but one made it to the ballot. They all required Michigan Supreme Court blessing to get to the ballot, and the reason for that is that the state commission that reviews these things to go on the ballot is made up of 2 Democrats and 2 Republicans. That's the way it is structured. And these initiative proposals generally have some political ramifications. And so they always fail at that commission. And so the courts have to get involved. And so in that year, they all went to the Michigan Supreme Court. One of them failed, and that was a proposition that granted gambling licenses, new gambling licenses and liquor licenses to certain properties. And of course, the petitioners had control of those properties, but that didn't make it to the ballot. 7 did, and it went 0 for 7. None of them passed. Now, obviously, some of them do pass, and I think in the last election there were again half a dozen propositions, and 2, 3, or 4 of them passed, and they are going to have a major impact on the state. Like Proposition 2 has to do with voting, in how voting is going to be conducted in elections, and when voting has to start, and having drop boxes and all that sort of thing. So and I have also seen it at the local level as well, both charter amendments as well as ordinance amendments.
Okay, next question. Is Michigan similar to other states in the area of referendum and initiative?
Yeah, not every state allows it. I think maybe, and I'm really kind of guessing here, I didn't check this out carefully beforehand, but 20 some states allow initiative and referendum. California has been doing this like crazy for years, and so they have some major things passed there, as we do in Michigan. So as far as I know, it is popular in many locations.
Okay. I'm not seeing any other questions in the chat. If you do have them, please put them in there right now. And Jerry, can you advance the slide so we show the next session dates?
Sure.
So just as a reminder to folks, we do have 3 more sessions, May 11th, July 13th, and September 14th. Please do spread the word for folks to register. Those sessions will be similar format and time to this one. All right.
And you can bring tough questions in and play Stump the Chump.
There you go. Ryan, I'm not seeing any other questions in the chat, so you want to close this out?
Yeah, great. So thanks again, everyone, for joining us today. Look forward to seeing you at future sessions as well. So thanks again. Take care.
Thank you, everybody.
Thanks, Jerry.